I just have a short presentation. I tried to make it readable, so I won't go through the details, but the main thing I wanted to stress in the beginning about board meetings is if you're on a board and you think, why the hell are these owners showing up to make my life difficult? It actually is the theory of the condominium law, which is the owners are supposed to supervise you, and that is why they're allowed to come to your meetings and ask questions, and as I point out, do a little more now. So it is, and it's probably better than having a state condominium czar come by and tell you what to do. At least the people trying to tell you what to do are members of your community. So keep that in mind. It may seem like those owners are a big pain and they're giving you a lot of trouble. And of course, the other thing you should remember, this is a problem for lawyers. A lot of what you guys do is not law, it's politics. So if you can help explain to those disgruntled owners who are carping about what you're doing, why you're doing it, that you've done your job, that you investigated, that will actually make your life easier. That's not it's not really a legal issue, it's just something that you as politicians really should keep in mind. And the other thing is, a lot of owners know things. I mean, attorneys are trained to pretend that they know everything and nobody can tell them anything, but I'm long ago realized that a lot of owners, a lot of board members know a lot more than I do about a lot of things, so you should never discount the information you might receive. So the first thing I wanted to point out is to implement that self-governance principle of the law, and that is a fundamental principle. When I was a condo specialist 30-odd years ago, that's what I would tell people. They'd say, we need you to come in and slap our board around and make them do this, and I'd say, I'm very sorry, but the basic principle of condominium law is self-governance. You guys are supposed to slap the board around and make them do what they're supposed to. It's not our job. There are a few exceptions, documents and financial information, but otherwise that's your job as an owner, and it's your job as a board member to expect that. So a few years ago, the legislature decided to make owner participation much more involved, because it used to be that the board could vote to say, we don't want to hear from any owners, they just have to sit there and listen. But the legislature in 2017, and I put in the changes they made, they decided no, owners should be able to participate. And the problem is, if you read this law, there's an argument that if you don't bother to adopt these rules on owner participation, there aren't any, so the owners can just jump right in anytime they want. So that is one reason why, as a board, if you want to control the process, you may want to think about adopting the rules that the legislature said you should, which are, you cannot prohibit, but you can control, and that's the purpose of your rules. I explained a few more things. You have to put more detail about what's on your agenda so the owners can say, yes, I want to go to that board meeting and put in my 2 cents worth. If you turn to page 2 of my materials, I suggested some rules you could think about. It's certainly not dispositive, but it is something. And now, there always used to be a tradition of an owners forum at the beginning of the meeting or sometimes at the end, and then the owners were cut off. No, they didn't necessarily have the right to say anything after the owners forum. If you read that law on the first page, that's probably not really what a board can do anymore. They have to allow participation as the meeting progresses. And just towards the bottom of the second page, owners' questions and statements can be limited to a maximum of X minutes, kind of up to the board. 2 minutes seems to be a standard limit, unless the board wants to hear more from that owner. And the main thing, and Rachel will go into that, you don't start having a slanging match with your neighbor. You're supposed to direct your questions to the chair. The chair controls the meeting. But anyway, a time limit on how long owners can speak. You can limit the owner's statements. Like if an owner stands up and starts going on about something the board has considered for the last 3 meetings and decided the meeting before there's no real reason the board needs to listen to the owner tell you something that they've already been through. So that seems to be a reasonable rule. If you've heard it all before, if you've already reached a decision, you don't necessarily want to hear it again. And of course, if 5 owners in a row say exactly the same thing, by about the second or third, you can say, yes, thanks very much. Mr. So-and-so and Ms. So-and-so made that point already, so we'll cut you off there. If an owner's going to ask an incredibly complex question that takes 5 minutes to present, it seems reasonable that your rules as a board could say, we want those in writing before the meeting. We're not going to try to answer those questions. We're not going to listen to a long presentation. We want them written up. And of course, one of the other things is you should try and limit owners to speaking after the board has been through all their discussions. Doesn't necessarily mean, even though owners have a right to participate, that they have to act as if they were board members. You can take their questions after the board has discussed. And top of the 3rd page, if an owner becomes disruptive, you don't necessarily have to let them do that. And sometimes it's hard if you don't have a policeman standing there. You may have to adjourn the meeting. You may have to try and have the meeting in a location where you have more control. And finally, you should know that owners are supposed to be notified of the board rules, and they're supposed to be able to get copies of them if they want. So that's something you should remember. My second little issue is board rights to exclude owners from board meetings. The real issue to me comes up concerning personnel. Rachel and I disagree on this, but I just included the American Heritage definition of personnel is not just employees, it's people who are active in the association. And part of the purpose of the executive session is because board members can't do a Vulcan mind meld and know what the other ones are thinking, they have to discuss things, and sometimes they will say things which might be considered slightly or very defamatory about a candidate for the board, candidate for the committee. So I think it's appropriate they can have that discussion, a full and frank discussion in executive session, and in executive session they get what's called a qualified privilege, which means you can, in that limited circumstance, say things which might be considered defamatory outside of that meeting. You can say them. So that's something to think about, is when can a board exclude on personnel issues? And again, there seems to be a little disagreement. I like to think I'm right, but Rachel just agrees with me, so. Number 3, board decisions by email or written consent. Again, if you go back to that basic principle I mentioned, the whole purpose of the owners being able to see what their boards are up to would be completely undermined if the board could decide everything by email or written consent. So that should not be something you regularly do. Top of the 4th page, you will notice that there is a provision in the non-profit corporations law that does allow votes to be taken by written consent. But again, that is superseded because the condominium law is pretty clear that owners have a right to attend meetings, accept executive sessions, and they have a right to hear what their board is doing. And if the board can do all this by written consent or email, a lot of that will be lost. So in an emergency, we would say to boards, you should not do this all the time. If you really have to make a decision, you don't have time for a meeting, you can do it by email and written consent, but you should ratify it at the next regular board meeting. In other words, you should make that decision, confirm it in your board minutes at your next meeting. So then at least the owners, even if they didn't hear why you did it, they can complain about it if they want to, because you will be bringing it up at a board meeting and ratifying it. So in that context, generally, subsequent ratification is pretty much as good as prior approval. Maybe not to a judge, but by the time they get to the judge, you will already have ratified it, so it won't matter that much. So, but it's something that is not something you should regularly do as a board, i.e. decisions by email or written consent. You should, and the other problem is if you give that authority and then the board has a change of heart between the email vote and the ratification, you may be out of luck, because if the president goes ahead and enters into some emergency contract to stop a leak, or the person who relies on the president will probably have a good basis for saying, hey, I don't care about the internal workings of your board. The president told me to do this, I did it, so you got to pay me. Number 4, board committees. Sometimes committees are formed because there's a lot of details that have to be worked out, investigated, and it takes a long time if the board does that at a meeting, so they appoint a committee. The way most documents are drafted, committees are not allowed to make decisions in a condominium. Sometimes you do have something in your condominium documents, and it's more common in HOA documents that a committee, like a modifications committee, will have authority to make decisions. But generally in condominiums, even if they recognize committees, they do not have the right to make decisions. They have the right to make recommendations to the board, and then the board makes a decision. And this brings us back to our original principle, which is the owners have to be there to keep an eye on you as a board member, so your committee can't go around making all these decisions out of sight of the owners. It has to be a recommendation to the board, brought back to the board considers it and then makes a decision, and everybody is in compliance with the law. Another use for committees is if you have a wild and crazy guy who has this theory that everything the board discusses should be broadcast to the owners, even executive session things. Sometimes boards create committees to do all of that discussing and then make their recommendation to the board. And they pointedly leave the blabbermouth off the committee because they do not want everything they discuss necessarily about personnel, about litigation, to get back to everybody, because that may work against the association. So that's another purpose for a committee. And again, when the committee makes a decision, if the committee starts making decisions, then it's really just like a board, and you have to follow all the same rules as a board. Plus, most condo docs will not allow a committee to act as the board. They will allow the committee to assist the board. And then finally, I just wanted to talk about number 5, top of page 6. Board discussions outside of a board meeting. You've probably heard of the Sunshine Law, which says that government boards and committees are not supposed to get together and discuss everything outside of a formal meeting. That law does not actually apply to condominium boards, and we have resisted it in the past. There have been proposals, and the way we've explained it to legislators is, here's a bunch of people living in a building, they're completely unpaid, they're volunteers, why shouldn't they be able to just discuss things? Again, the main thing is their decisions should be made so the owners know the decisions, but to me at least, it seems unreasonable if you're a bunch of people living in a building and you talk about board business, that should be illegal because there's some kind of sunshine law saying no more than 2 board members can get together at any one time and discuss association issues. But that is a question that comes up sometimes. And again, going back to the principle on the very first page at the top, you are, as board members, supposed to try to let your owners know what you're doing, what you're planning to do, because they are, under the law, supervising you and making sure you don't go off the rails and make a lot of problems for the association, which is not unknown, unfortunately. Some boards, that happens. So, but there is no real sunshine law applying to condominium boards, and again, the reason we've always presented to the legislature when this type of legislation is proposed is, why should unpaid volunteers who live in the same building not be able to talk about association issues? Every other owner in that building can talk about association issues. It just doesn't make sense in this context. And so I pointed out that the sunshine law, so to speak, is dealing with government, commissions, agencies, boards. It's not dealing with condo boards. So those are my few little points. I think Rachel is going to disagree with me on some of that too.